Good day and welcome to another episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Donawa, and I am pleased once again to bring the law and you. Of course, you can stream us on wesncc.com and on all social media platforms. Today we have an interesting topic on copyright and fair use. What is fair use? We see it a lot of times where persons disclaim that they do not own the rights to this music or this production or this video that has been posted on the World Wide Web or other mediums. Now, I won't want to get too much into the into the law as yet because of the fact that I have a guest in studio once again, Mr. Jason Natu, attorney at law. You would have seen him previously discussing the difference between copyright and the trademark. And as you know, this week we've had a lot of discussions on the trademark issue of the word juvie. Of course, we would chat about it just briefly, but of course I want to bring this particular topic of copyright and fair use to you. Now, Jason, of course, is an attorney at law of over 14 years experience in litigation, intellectual property, family law. He's a tutor at the Hewarding Law School Legal Clinic. Now, let me welcome my guest today in studio, Mr. Jason Natu. Good morning.
Good morning, Rondell. Thank you for having me again.
And how are you?
Not too bad. Trying to survive the pandemic like everyone else.
Well, that was my next question. How are you coping?
I am coping.
Right, so let's get straight into the discussion. We hear fair use. Tell us, what is fair use?
All right. Well, maybe we should remind ourselves first about copyright.
Of copyright,
so, copyright is a right that is available to artists or authors to protect certain works. So you're talking about literary works, you're talking about dramatic works, artistic works, photography, etc. And it gives the owner of the copyright the exclusive right to do certain things, to reproduce, to distribute, to import, etc. So when we talk about fair use or fair dealing, what that is a limitation on that exclusive right that is held by the copyright owner.
And when we say limitation, if you guys break down, what is the limitation?
So what it does, it allows someone, an ordinary user, to use somebody's copyrighted works, but in very limited circumstances.
And what are the circumstances in which you can use copyrighted work? And let's explain what type of copyright work is in this regard.
Sure. So when we talk about what types of work, we have to go straight into our legislation. So it's interesting you spoke about fair use. And fair use and fair dealing, same concept. You see fair use a lot because it comes straight out of the American legislation. So a lot of these sites that we know, the social media sites, etc., because they're based in the US, you would see fair use notices, etc. But just know that fair dealing, the concept of fair dealing is the same. So if we look at our local Copyright Act, the Trinidad and Tobago Copyright Act, there are several exceptions to the rights that are enjoyed by the owners of copyright. One of them, for example, is private reproductions for personal purposes. There are exceptions to that as well, because there's always an exception to everything. So you cannot make a personal reproduction, for example, of an architectural drawing, because again, that's something that's very commercial in nature. You can't make a private reproduction of a computer program, because what would be the point of purchasing a computer program? But you can, for your own personal use, make an audio recording or a copy of a printed work, for example. So private reproductions for personal purposes is one of the things that's exempted.
And when we say personal purposes, it does not include for the purpose of streaming on the internet or something?
No. This is just for you to enjoy in a very private capacity, not communicate it to any audience. Right? So another exception under this fair dealing principle is quotation. If you're referring to a work, you want to take an excerpt to reference in some other document, for example, you can quote it once you attribute the source and give the attribution to the author of the work. So quotation is allowed as well. Reproduction for teaching purposes is also allowed to a certain extent, so you would want to have short excerpts that you may be able to use for teaching. For example, if you were doing some sort of illustration in class or some activity, you may use somebody else's work in that context, but again, there are limitations on that. For libraries and archives, you may be able to use works in that capacity as well. And of course, for news reporting, you would want to be able to refer to some copyrighted work in a news report for public interest.
And what about music?
So music, again, it depends on what it is. So again, a private reproduction for personal purposes, you would be able to use that in that way. You could use a musical work again in teaching. And if you were doing a news report, for example, on an artist or a song, you can use a portion of it there. But other than that, there's no outright exceptions specifically for music.
Now, you see oftentimes on the media, particularly when persons upload music, let's look at video content, musical content or whatever it is, on social media or on YouTube, and they put the disclaimer, I do not own the rights to this music. Is that considered a limitation to the fair use argument?
No, it means absolutely nothing, actually. If you don't own the rights to something, then you have no business distributing it or disseminating it. Just by saying, I don't own the rights to this, doesn't absolve you from any liability that could potentially arise.
So why do people even post that, or what are the alternative to such a phrase?
Think this really results because in the US system, there are certain characteristics of fair use, but that, of course, is different to our circumstances in Trinidad and Tobago. We follow a Commonwealth principle. So in the US, for example, they look at the degree to which you use it, and of course, American law is very different to ours. So some of the websites like Facebook or YouTube, etc., would be based on American law.
Yes.
But in the context of Trinidad and Tobago law, and if you're using Trinidad and Tobago content, then that does not apply.
Right, so we say that once somebody posts that I do not own the rights, they cannot, of course that doesn't mean that you
It doesn't mean that, correct.
Now, what can somebody do to ensure that they do not infringe on someone's copyright if they are reproducing, or rather if they are doing a cover for a music item?
Okay, so again, we need to look specifically at our law. In some jurisdictions, some other Commonwealth jurisdictions, like the UK, for example, they allow you to use some works for parody or pastiche. So you know those TikTok videos and so on where people use parts of songs, they may be permissible in the UK, certainly in the US as well, because they have similar provisions. But in Trinidad and Tobago, that's not specifically in our legislation. So in our legislation, copyright protects reproduction, and it also protects adaptation. By doing a cover of a song or putting your own spin on somebody else's work, that's an adaptation. So you have to seek the relevant permission from the copyright holder before you engage in any activity like that.
And if you are to seek permission from the copyright holder, what type of permission that will be in terms of, do they now give you a document to sign, etc.? Right.
So remember, intellectual property, copyright is a subset of intellectual property, is like any other type of property that can be transferred or transmitted to someone else. The instrument by which that is done is called a license, and a license is essentially a contractual arrangement. Now, we know contracts can be oral or contracts can be written, but of course, when you're dealing with things like rights, it's really important that you have these things in writing and that you understand the terms and conditions of the license, because it can be very varied.
And what are the examples of license that that a copyright holder
in copyright, you could have a license that is exclusive, giving someone the exclusive right to use a copyrighted work. You could have something that's not exclusive. You may have something that is limited maybe to a certain activity. You can, for example, if you are throwing a carnival fete, you would be presumably playing music at that fete, and you would have to obtain the license to do that from the relevant holder. In that case, maybe it's one of the collective management agencies that deal with music. So you might hear somebody talking about a cut license, for example. That's what it is. It's a license to play music, but specifically for that event. It's not a license to play music willy-nilly at every single event that you're holding. So it could be limited to a certain event. It could be limited to a certain purpose. For example, a lot of photographers, they upload their photos to a website like Getty Images or something similar, and bloggers or website creators can now obtain a license specifically for the purpose of that website, but not just willy-nilly again for any purpose. So it could be exclusive for a certain reason, for a certain event, etc. So it's important to negotiate and understand the terms and conditions of the license when you're engaging in that activity.
So therefore, for instance, as you mentioned, photographers, a lot of times they produce photos, they upload it on websites with their watermark.
Right.
And you will often see that persons who are probably doing another threat or want to use what you call a stock image, and they decide to copy that image and put it on their particular website or promotion. What is the law with respect to that?
So you cannot do that unless you obtain the relevant license. The license may be either from the photographer himself, or the photographer may have delegated or has a sub-license with an entity that deals specifically with that. So you need to get the proper permission to do that. Otherwise, you are in breach. You are infringing on the copyright of the photographer.
And let's say, for instance, you see a lot of programs, let's say, like, for example, I don't want to use this example. Let's say this program, and you have music that is being played in the background, introducing the program. Is that considered fair use because of the time, let's say 20 seconds of someone's intellectual property, particularly like that it's an educational forum?
So the music for this program is more than likely stock music that was obtained via a stock website for which some sort of license has been obtained. So it's very specific for this program, and the intro doesn't change. It's the same intro every week. If, for example, we were here talking about a specific song and we played 20 seconds in the course of our discussions, that would be fair use. But the intro music, the program, is not fair use. That was obtained via a license.
And then there was some time ago where I think it was Marshall Montano. I think there was some program abroad whereby they would have used his song and remixed it into another work, and then they claim that would have been, they only use a certain number of seconds. Is that fair use, or basically you require a license for adaptation of that particular work?
So I'm not familiar with that particular example. In Trinidad and Tobago, you would require a license for that purpose. But again, if this occurred in the United States, for example, and the governing law was American law, there may be other considerations that I'm not able to speak about.
Right. And let's say, for instance, what are the do's and don'ts when you grant someone a license?
Okay, so you need to understand the terms and conditions of your license. It's important to negotiate if you can. And you know, for example, when we use those websites, social media sites, YouTube, Facebook, etc., there's the terms of use that people don't really read, but we click on I agree.
Yes.
But most of the times you really haven't read it through, and they deal with all the terms and conditions like these. So it's important to review what you can and what you cannot do. Understand the duration of the license, understand what the license covers, for example, before you embark on anything like that. And of course, I would say obtain legal advice if you're unclear about anything.
And what are some of the remedies in our jurisdiction with respect to an infringement, and whether or not that is successful, or whether or not it has been tested in our in our jurisdiction?
So the jurisprudence is developing in Trinidad and Tobago. There have been many claims that were brought for copyright. Many of them have not made it through the court system because very often people tend to settle in these types of matters. And of course, now the court system fosters a more amicable approach and trying to find resolutions outside of the expense and time of court. There are some matters that are currently before the court. There was a judgment recently on photography. So we are seeing some development in that area. In terms of the remedies that are available, well, litigation is always available to someone who alleges infringement. But other than litigation, I mean, there are several things that can happen if you breach copyright, particularly on the internet. In this digital age, your content can be taken down, and some of the sites are very vigilant about that. YouTube, for example, is very vigilant about taking down content that infringes. Because again, remember, it's part of the terms and conditions of your agreement with those sites. You can
have copyright claims.
Correct. There are lots of copyright claims. You can even have your account suspended or banned from because of posting content like that. So those are risks that are available. And then, of course, there may be non-traditional remedies if you engage in some sort of alternative dispute resolution, that creative remedies, for example. But it really depends on the circumstances and what the parties want out of the.
But let's say, for instance, YouTube can only pull down a protected material if that protected material is recognized.
Correct. But when it comes to music, because the music industry is so developed, very often record labels have deals with collective agencies throughout the world. So you may find that something that may seem very obscure actually is protected in multiple jurisdictions, so that it will be part of the algorithm and they would be able to recognize the beats and would be able to take it down automatically. Other than that, there's always a reporting mechanism where a creator can report that this is my work, and that can be investigated very quickly, and if there's merit in that claim, then they will take it down.
Now, I know we earlier in the program we discussed about I do not own the rights. There's also a phrase, a disclaimer persons use, where it says that I do not intend to infringe on anyone's copyright. I recognize the owner of this copyright. If they recognize who is the owner of this copyright, is that considered fair dealings for the purpose of recognizing
No,
that
Rondell,
owner?
it does not. I saw a report this week that a gentleman was fined by a magistrate for breaching the curfew order. He says he knew it was after the curfew, but he just took a chance anyway, and he pled guilty. He was fined. So it's the same principle. Just by saying I acknowledge somebody else as the owner doesn't mean that you are absolved from liability. That may arise.
And in our jurisdiction, is there also a criminal element?
There are criminal aspects to copyright infringement as well. They are both civil and criminal remedies, but you find that the criminal remedies are really in very high commercial cases. And it certainly has not been exploited very much in this jurisdiction. The only instance I know of criminal remedies has been the traditional man selling CDs down on the promenade or DVDs, where the police will come and maybe make them pack up and leave.
That, yes.
But other than that, I'm not sure whether that's been tested very much.
Right. So let us veer a little bit.
Sure.
This week we've had a lot of debate, or we've seen where there was an explosion of persons dissenting when a famous American actor, Michael B. Gordon. Sorry, not Michael B. Gordon. Michael.
Yes, Michael from
Black Panther. Yes.
Michael Jordan.
Jordan.
Yes.
Michael B. Jordan.
Yes.
Right, and it was with respect to the trademark of
Correct.
the word juvie.
Correct.
A lot of arguments were that it is cultural appropriation, and that they were stating that the word juvie, according to that mark, that they would have tried to register, that it has no meaning. Could you just explain in terms of trademark and the explanation of what is really trademark and how can that be
Sure.
an infringement?
So a trademark is a sign that is capable of distinguishing a product or services from those of your competitor. So one of the elements of a trademark is that it must be distinctive. Juve, the word Juve, would never be distinctive in Trinidad and Tobago, anywhere in the Caribbean, because it is something that is ingrained in our cultural identity. But Juve is certainly not something that is distinctive in the United States. It seems very open. And one of the elements of a trademark is that it is registered specifically for the class of goods and services. So I think we spoke the last time about apples and computers,
yes.
and Apple is not necessarily indicative of computers, so it's distinctive in that regard. So Mr. Jordan registered in the US the word Juve in respect of alcohol, specifically rum. So that doesn't mean that if someone in the US were to use Juve for a festival or for any other product or service, that they would be barred from its use only specifically for rum. Another thing about trademarks is that they are territorial in nature, so you have to register your trademark in every jurisdiction in which you plan to use it. So a registration in the United States will not be binding on Trinidad and Tobago unless the mark gets some sort of well-known status, for example.
So do you think so therefore how does the law on trademark and cultural appropriation combine?
Well, cultural appropriation is really not an element in terms of trademark registration. I think there was a flaw in Mr. Jordan's trademark registration in that the registration alleged that there was no translation in any other language.
Yes. That was
because that's one of the elements. You
yes.
must disclose to the office whether there is a registration, a translation of the mark. We know that it's J ouvert, day opening, but if you just look at J apostrophe OUVERT, it could even be I open. So obviously there is a translation. So it seems as though the examiner at the US IP office faltered in some way by not recognizing that there was a translation, and then that opens the question whether it can be challenged, whether it can be cancelled, for example. Luckily, none of that really arises now because I saw that he's decided he's not going to use the name, he's going to rebrand. But in terms of cultural appropriation, it's not really a factor for the United States because Juve is not indicative of the United States. Again, for Trinidad and Tobago, anywhere in the Caribbean, you would never be able to register a word like Juve. In respect of alcohol, because we know Juve is something that is very cultural to our islands and to our jurisdictions.
Now, I think there has been a lot of misinformation in the media because persons were of the view that the mark was being registered as ownership in terms of whether or not he is appropriating the mark to own it. But that is not in fact so.
No, he was just registering a word that he would use for his brand, specifically for alcohol, but not for any other purpose other than alcohol.
And let's say, for instance, if you are to, and it's important to actually note that that mark has to be registered in each jurisdiction.
The mark would have to be registered in each jurisdiction, and if he were to export his product to the Caribbean, I am certain that it would be refused in our jurisdictions.
Now, does that now open the conversation as to empowering or rather informing our population of the use of trademarks and the importance of registering your brand?
I think it is important for anybody who engages in business activity to think about their intellectual property, to think about their brands, to see it as an asset that can be bought or sold or licensed, as the case may be, because it does add stock to your image, to your company, and there is certainly some value in the brand, and it's important that you embark on the process of an IP audit to determine what your assets are. Your assets aren't necessarily physical plant and machinery or cash in bank. Your assets also include intangible things like intellectual property.
And of course, I know we would have explained previously with words. Words can is it that the word Juve can be trademarked in terms of an image? Meaning that, okay, because Juve is words, right? You can trademark words.
You can trademark words. You can have a combination of words and an image. You can have an image only. You can have a slogan. You can have a sound. In some jurisdictions, you can even trademark a smell. You can certainly trademark a shape. So there are many facets to what constitutes a sign that is capable of distinguishing my products and services from those of a competitor.
Do you think that that now that there has been a lot of discussion in terms of law with respect to intellectual property, that our laws needs updating?
Well, actually, our Trademark Act has very recently been updated. Earlier this year, I think the new Trademarks Act came into effect in January 2021. So our Trademarks Act is very much up to date with modern developments. In terms of our other
like copyright legislation,
there certainly may need to be some updates of the legislation. I think that the IPO, and there's been a committee that's working on that, because, for example, we were talking about the fair use, and in the UK they have parody and pastiche. That's not in our legislation. So again, there are certainly areas where there should and ought to be some developments.
Particularly in light of the advent of social media. I think that our legislation does not really touch on social media use, because we have a lot of infringement-based claims in the US with respect to TikTok, particularly. So how can this be incorporated in Trinidad and Tobago?
One example where that came to life very recently is coming back to what we were talking about, fair use. So I spoke about fair use for educational purposes. Our Copyright Act actually says, when you're talking about education, using limited use of material for face-to-face teaching. Face-to-face teaching. We've had a pandemic. Everything transitioned to online. There was no face-to-face teaching. Does that now mean that you can't use anything for electronic teaching?
Well, by law you can't.
Well, by law you can't, but it's only common sense that it must be extended to electronic teaching as well. But I think it's important that the public understands that even though there is some fair use, there are limitations. You can't be distributing whole textbooks. Teachers can't be copying entire books and making them available in packages to students who can't access, for example. There are limitations on what you can do, and it has to be very short and very isolated.
But that is a discussion that is continuous, because I can imagine after this pandemic, electronic learning will still be a thing.
Certainly, it will be here for a while. So, for example, teachers, because I know a lot of teachers struggled with this area in terms of copyright and so on. You know, if you're doing an exercise in class and you want to share a page from something just to do some kind of activity with your students, that's fine. That's fair use. That's fair use, falls right in fair use principles. But you can't now make an entire PDF book available to your students, and we've seen that happening.
Yes.
We've seen that happening.
Even open libraries where you can download.
No, but that's
everything.
different now. Now you see, well, open libraries now, but libraries very often have some sort of collective license, and many educational institutions obtain some sort of collective license.
But online, because if you Google, and you can go and you can see PDFs to download.
So again, there's the legal online open libraries, and then there are the illegal ones. So again, you need to look at common sense in terms of what is legal and what is not. Many of the classics, for example, books that were where the author has been dead for many years, those books are freely available online, because remember, the copyright also has a duration. In Trinidad and Tobago, most works are life of the author plus 50 years. There are some exceptions where works are owned by entities or corporations, or if they're joint works, etc. It may be 75, it may be more, but normally it's life of the author and 50 years. So some of the classic works of literature are available freely online, and there's nothing wrong with that. But you can't now go downloading something new via PDF when it's on sale. It just released and it's on sale on Amazon, or download music via those torrent websites that were popular back in the 90s and early 2000s. That is certainly illegal.
So therefore, it's indeed to really know your intellectual property rights.
Yes.
As well as,
always obtain advice.
Indeed, always obtain advice. Don't take things for granted because you can end up at the wrong end of the stick.
Exactly.
Right, Jason, thank you so much for coming once again. We're out of time.
Certainly.
And I appreciate your presence here.
Anytime, Rondell.
You have been watching Strictly Legal on WESN Content Capital. I had my guest with me, Mr. Jason Nassau, attorney at law, discussing copyright, fair use, and a bit of trademark. See you once again for another episode next week. Have a good day. God bless.